I wanted to bring to your notice also some how can I say this is not the first time. Just prior to this, a month back, an incident took place. A pamphlet is circulated, but it is not accurate. But from your sorry, this is not that you are not a law people, person concerned with law. That a medical scam, a case relating to medical scam, it rocked the Supreme Court and other places. CBI registered a case against a retired Orissa judge. It is said Allahabad. It is not Allahabad. It is a Orissa judge Kudus and others registered the allegations in the FIR where that these people, particularly Kudus and others, they conspired and Kudus, sorry. He assured them, don't worry, I will get you the order which you want. It is for medical colleges. Now it is a privatization of medical colleges. Not only now state is the player in the education field of education. Now the private medical colleges are now established their institutions. Now they collect lot of the capitation and they charge heavy fee and so much. And this, there are some problems with the Medical Council of India and those colleges, and therefore Medical Council of India put some conditions. These institutions go to Supreme Court and they get orders to establish the courses, colleges, and all those things. There were the issues. There is a bench headed by Chief Justice Deepak Misra. They were hearing these medical college cases, and at that time, Kudus was charged with the allegation that he assured them, give me some amount, bribe, I will get the order from the Supreme Court. He did not name the judge from the Supreme Court. At that time, the bench which heard the medical college matters was the bench that was headed by the Chief Justice Deepak Misra. Then, the Prashant Bhushan's organized CJIR, that Judicial Accountability, they have an organization, and that organization filed a writ petition in the Supreme Court. Their prayer was CBI cannot investigate because we have that lot of credibility, lots of credibility to CBI. These institutions are one-sided, biased towards the state. Therefore, there should be a special investigation team shall investigate this matter. In view of the judges are also likely to be accused. Therefore, let there be a special investigation team investigate this matter, and a retired Chief Justice of India shall supervise the investigation, was his prayer. And when it came before Justice Challameswar, they represented the matters are heard by Deepak Misra bench. Therefore, you constitute a bench. He accordingly said that let the issue be decided. At that time, I think it was either 2 or 3 judges that was headed by Challameswar. He said, list the matter before 5 senior judges next to Deepak Misra. That was the order passed by him. Next day, Justice Deepak Misra constituted a 5-judge bench. It is an order passed by 3 judge bench, constituting a 5-judge bench to inquire into the matter, to decide the issue. Next day, Justice Deepak Misra constituted a 5-judge bench. He overruled or he reversed the order passed by Justice Challameswar, saying that he could not have done that, and he allotted that case before a 3-judge bench, and that 3-judge bench dismissed the case, not appointed a special investigation team, and besides dismissing the case, they imposed a heavy fine of rupees 25 lakhs on Mr. Prashant Bhushan. This is shocking. There are 2 things. Whenever you go to public interest litigation, you are asked, so sorry, we cannot entertain your writ petition. That's a different matter. Sorry, if we have some difference of opinion, we are not willing to issue the direction which you want. That is one thing, and asking, behave properly, pay 25 lakhs cost is a different thing. In fact, Justice Singhvi, a retired judge of Supreme Court, and A.P. Shah, he was a Law Commission chairman, and he was the former Chief Justice in Madras High Court. Both of them condemned about this imposition of fine. Why I am saying this particular instance is, this happened I think on 1/12, but just before that, on 26/11/2017 is the law day. 26/11/1949, the constitution was adopted in the Constituent Assembly, and it is being every year celebrated as a law day. And it came into effect from 26/1/1950, it is not 11. And in New Delhi, in the law day function, the Prime Minister, the Law Minister, Ravi Shankar Prasad, Mr. Ravi Shankar, and the Chief Justice and other judges were sitting in the law day function. The Prime Minister and the Law Minister, normally on those occasions, they used to speak. These constitutional authorities, like courts, executive and legislature, they cannot encroach on others' domain. That is the general talk during those occasions. But on that day, the speech was, the High Courts and Supreme Court cannot rule this country by way of public interest litigation. Was the message put forth by the power on 26/11. Then they followed this order. I don't know that this is a maybe coincidence, but that was I hope it may be taken as also some sort of a threat. The public interest litigation was devised by Justice Krishna Iyer and even Bhagavati. Though he rendered that ADM Jabalpur case, later he was a champion of the human rights, and he rendered landmark judgments, and they devised this public interest litigation. Even a person in the prison, he can write a letter. That letter can be taken as a writ petition. That can be inquired into. He is the device, because more than 50%, I may say even 70 to 75% of persons, they cannot afford to go to the higher judiciary. It is so costly. Therefore, they adopted this type of methods. When Khadija B was a widow of an electricity board, she wrote a letter, I am not paid pension. Justice Chinnapareddy inquired and ordered to pay pension. That letter was treated as a writ petition. That is how it was developed. Now, it is not encouraged. Now they want to bury. They say it is a publicity interest litigation. It is not a public interest litigation. And the latest instance is, why I am saying is this is the trend against the democratic principles. There is one the movement called Makkal Padai. In Tamil, Makkal Padai. It is the leader of this organization is Mr. Sagayam, IAS officer. He is serving IAS officer. He is an upright officer. He faced 25 transfers in 20 years. This Sagayam says, in Tamil he says, Lanjam Olithu Nenjam Nimirthu is a slogan. And he organized, he opened IAS Academy in Salem for the free coaching, and wanted to have a public meeting against the corruption on 17/11/2017, in which another IAS officer, Devasagayam, was to address, and is a retired Mr. Devasagayam, and another Vice Chancellor of Gandhigram University, and Principal Accountant General retired Nagal Swami, they were to address along with Sagayam. But at the last moment, the permission was declined. All you know, Salem is now a holy town. You know why it is a holy town. Therefore, it is denied. Then went to a High Court. High Court dismissed the writ petition, imposed a cost of 10,000. Fortunately, the division bench, I think headed by Rajiv Shakdar, set aside that order, and that trend. Therefore, it is not people friendly. The PIL, this I don't understand. It was a public meeting against corruption. Corruption cannot be wiped out in a public meeting, but we have fundamental right of freedom of speech and expression to have a public meeting. We have a hall meeting. This type of the right, we have a right, people have a right to exercise these rights. But why I am saying this happened at this time, it is November, all these, whenever there is an order from Supreme Court, it will have an effect all over the country. They impose a cost of rupees 25 lakhs. Here it will be followed in other case. They used to, there was a threat. There will be a threat in a public interest litigation. What do you say? We will also impose. Then I just wanted to say, if I say simply, is it an emergency like condition? Is it like Mr. H.R. Khanna, Justice who resigned? Is it such a condition exists? You may ask. In my view, yes, it is just like an emergency situation. Why? In 2004, there was, I like to narrate 3-4 instances they have given in that pamphlet, but I want to give a little more explanation about the Israt Jahan encounter case. That in Gujarat it had happened in 2004. Yeah, then Jayant Patel was a High Court judge in Gujarat High Court. He ordered CBI inquiry. Because the state police, Amit Shah was also one of the accused. Therefore, a CBI inquiry was, it's a central agency. For instance, as a sitting judge in Madras High Court, in Dindivanam, I forgot his name, when one minister, he was attacked. And one person was, there was a murder in his house by the Patali Makkal Kachi. Mr. Ramadas, Chandumani, all were shown as a party. For 5 years, no investigation. I ordered CBI inquiry because that was there was a party's alliance with the ruling party at that time. Therefore, the case was not inquired at all. I ordered CBI inquiry, and after the inquiry, Mr. Ramadas and Anbumani were dropped, and others were proceeded against. That's a different matter. But they ordered CBI inquiry. After coming into power, at that time he was, after 2014 they came to power. Without power they can't touch a High Court and Supreme Court judges. Now they are at center. Now what they did, they transferred Justice Patel, who was acting Chief Justice at that time in Gujarat, to Karnataka. In Karnataka, 2017, on 8/10/2017, he was number 2 in Karnataka High Court. He was next to Chief Justice. Chief Justice was to retire. Why he was transferred? For 2 reasons. One, go out of this state. Number 2, you can't be acting Chief Justice. Acting Chief Justice is as good as a Chief Justice. Suppose there is no director in your institution. There is acting director. He will carry out all the duties he can pass any order which a director pass. Therefore, acting Chief Justice, he was transferred to Karnataka at the second place, where he cannot exercise such power. Then, that 8/10/2017, the Chief Justice retires, he will automatically become acting Chief Justice. To thwart that situation, he was transferred to Allahabad by the collegium. That I want to have also a discussion. In that collegium, these 4 judges also were present. Therefore, we should also ask them, why you transfer this person? This Jayant Patel, on transfer to Allahabad, he had only 10 months service. And all his juniors, he put in about 16 years of service. I rendered only 7 years. If a person put in 16 years, will become Chief Justice and go to Supreme Court. But he was not allowed to become Chief Justice. When 10 months time was there, he was shifted to Allahabad. He resigned. And there was a strike at Gujarat by the lawyers, even in Karnataka, protesting against his transfer. Then does it not resemble like emergency? Number Israt Jahan not only took the life of Jayant Patel, she also took another person by name Gopal Subramanian. He is a senior advocate of much reputation, and even in Trivandrum, Padmanabha Swami temple case also, he was appointed as amicus curiae, and to assist the court he was appointed. And in the Israt Jahan case, he was amicus curiae to assist the Supreme Court. Supreme Court appointed him, where he did his professional work. He said some case is made out against Mr. Amit Shah, for which when he was recommended by the Collegium to Supreme Court along with Larryman, the present dispensation sought that he is not elevated and he did not become Supreme Court judge, Mr. Gopal Subramaniam. These are all the two instances regarding that. Third instance, I like to state about, you may be aware of this bakery case. In 2002, in Gujarat, there was a riot. About 2,000, at least the number varies, more than 2,000 Muslims were killed in that riot. And in the West Bakery incident alone, one place there was burnt alive 70 persons. That West Bakery case was transferred from Gujarat to Bombay. Like our Jayalalitha wealth case is transferred from Chennai to Bangalore for a fair inquiry. Otherwise, the Tamil Nadu government could they prosecute against the chief minister? Therefore, it was transferred. Some VIPs, important persons are involved in West Bakery case. I think some minister is also involved. Therefore, it was transferred to Bombay. That was decided that the trial was conducted by Dipse, like Kunha. You compare Kunha, like Dipse. Kunha also became High Court judge. Dipse convicted 9% to life imprisonment. Some persons he acquitted, but life imprisonment was given to 9. And this Dipse became High Court judge. Then in 2014, after coming to power, Dipse was again transferred to Allahabad. I don't know, Allahabad may be a punishment place. Here in Tamil Nadu, the state service we used to send to Kanyakumari, the farthest place. I don't know. He also retired now, Dipse. And one more example I may cite is Rajiv Shankar. Rajiv Shankar of Delhi High Court. He quashed the lookout notice issued to Priya Pillai, a Greenpeace activist, to preventing her to go abroad. That notice was quashed by Rajiv Shankar. Therefore, he was transferred just immediately after retirement, a week after retirement, my retirement, he was transferred to Chennai. Now on 16th he went back to Delhi. There was a lot of protest, including Mr. Venugopal, Attorney General, expressed the view that this transfer is bad. All these instances, these collegium did that. These 4 judges are accountable in my view. They should also come out to the people why they also did this. These are all the instances resembling. They said 20 years after people will allege. Now I think we may allege. We make allegations. Why Jayant Patel was shifted to Allahabad when he has only 10 months service? Why Dipse was shifted? Why Justice Rajiv Shankar was shifted? These are all the issues. Now it has to be answered.